Well, welcome. Thank you for joining today's webinar, Product Liability and Expansion to the U.S. My name is Sarah Larson. I'm the Marketing Manager here at Invest Buffalo Niagara, the Buffalo Niagara region's economic development organization. If you've attended a past webinar or you receive our monthly Canadian business newsletter, you've been introduced to Carolyn Powell, who is Invest Buffalo Niagara's International Business Development Director. She works with Canadian businesses considering an expansion to our region. And when you visit Buffalo Niagara, Carolyn introduces you to a variety of local partners who will be able to assist you during your expansion process. One of those potential partners is with me today for this presentation, Craig Leslie with local law firm Phillips, Lytle. Craig concentrates his practice in the area of tort litigation, products liability and product safety, commercial litigation, and real property valuation and tax assessment. Craig, thank you for being with me today.
Thanks for having me.
Before we begin today's presentation, just a little bit of housekeeping. If you have any questions during the presentation, please type them into the question box in your GoToWebinar control panel. We will take time for questions at the end. Following this presentation, you will receive an email with a link to Carolyn's calendar if you wish to schedule a one-on-one conversation with her. We will also make sure you have both of our Canadian guides to expansion to the U.S. But for the next 30 minutes, we'll speak with our legal expert. And without further ado, I will turn the presentation over to you, Craig.
Thank you, Sarah. Hello, everyone. As Sarah introduced me, I'm Craig Leslie. I'm a partner at Phillips Lytle, and I spend a significant part of my time working on products liability cases, both in the United States and Canada. We have a number of clients that have a footprint in both countries or distribute products in both countries. So today I'm going to try to give you an overview of some of the product liability considerations that are attendant to expansion into the US or distributing products into the US. I'm going to talk relatively quickly, so forgive me for that, but it's a relatively expansive field to cover, so I want to cover as much as we can in the time that we have. So I'm going to start with the key takeaways, and this sort of will come full circle at the end. But there's two key considerations here. If you're already selling products in the US, you already have exposure to the jurisdiction of the US courts. So you can already be sued in the US if something goes wrong with one of your products, obviously. And in the United States, that exposure can exist even if you're not negligent in what you've done in terms of designing, manufacturing, or providing warnings with your product, which is a little different than in Canada typically. Now, if you're considering expanding into the US or starting to distribute products, as always, you should seek both legal and insurance advice before selling your first product in the US, because once you sell that first product, you have the potential exposure there if something goes wrong with it. And you need to make some plans before that happens in order to best protect your interests. I thought it would be helpful to give you a little bit of a hypothetical case study. This is based loosely on a call that came in, and names and products have been changed to protect the folks who called in to us. But this hypothetical envisions a Canadian startup company, a couple of folks who are out of college and have started their own business that produces a laser engraver cutter for personal use, something that you might use to engrave a checkbook cover or a piece of leather or other material in your home or in your classroom if you're a teacher, something like that. In this case, we're envisioning it as an open source product with customizable hardware and software. So the makers have created this kit so that folks can modify it for their needs, and they can change the software, get to the code, and change it to do some other things if they can figure out new things to do with it. We have an instruction manual written by the inventors that encourages users to share modifications on the company's website so the product can improve and so the maker community can take this kit and do different things with it that they might not have envisioned yet. Now, in this instance, the startup's already selling the initial prototype version of the kit to US customers, taking its orders over the internet and mailing the kits to US addresses. It is operating as a DBA, not yet incorporated, and it has not yet secured insurance coverage against product liability suits. So in this sort of call, when I get the call, there's a number of steps that we sort of work through before we get really to the meat and potatoes, the product liability issues. So the first issue, obviously, if you're going to be doing business and exposing yourself to liability, you want to be incorporated or formed in a business organization that protects you from potential liability or limits your potential liability. In the US, it may be a limited liability company, it may be a limited partnership, it may be a corporation, but you want to have that layer of protection between your personal assets and the potential exposure. Second issue is the insurance coverage. You want to make sure that there's applicable insurance coverage that's going to cover the distribution of products in the geographic territory where you're shipping them. If you're insured in the Canadian market for the distribution and sale of your products, but there's a geographic limitation, it's not going to do you much good if you ship a product into the US and are sued in the US. And as we'll talk about a little later, the cost of defending the suit can be just as significant as any potential liability or judgment you might have to pay. And the third issue I highlighted here in part because of the fact I bridged that gap between product liability and product safety. You need to be aware of whether the product you're shipping into the United States is regulated by the Consumer Product Safety Commission, which role is similar to, but not always identical to, the role played by Health Canada. The last issue I get to are the product liability concerns and how you deal with those and how you minimize your exposure. So the question of whether your product's regulated by the CPSC could be a topic unto itself. The CPSC has a list of regulated products available at its website, which you can go to and find out if your particular product is subject to some heightened regulation or regulatory standards. There are, of course, special rules for products intended for children, and then there's a list of products that may not always be what you might expect that are subject to some heightened regulations because of various statutes that have been passed in the US. I wanted to give some examples just to highlight the fact that you really do need to check this because some of them are things you might not expect. Art materials, ATVs, children's products, of course, clothing, textiles. There's a whole body of regulatory law about fireproofing and what you can do and what you can't do with certain textiles, choking hazards, garage door openers, things that because of a particular injury or particular concern have received some heightened attention. And there are a number of consumer products like hair dryers, lawnmowers, sleepwear, again, for some of the flammability issues, and even certain swimming pool toys and accessories. So they're not always things that you would think are hot button issues or hot button products, but the CPSC has authority to regulate them, and there may be specific requirements and certifications you need to have in order to ship those products into the US. So turning to product liability now, Canadian product liability law versus US product liability law. Canada's product liability law is relatively uniform across all the provinces except Quebec. Quebec is a civil law jurisdiction, so it shifts some of the burdens of proving the product is safe, but we won't get into too much detail. You folks probably know about those differences already. US product liability law is primarily set at the state level, and it's a 50-state mosaic or patchwork of laws, and there can be significant differences from one state to the next. There are different tests used to determine whether a product will be considered defective. There are different defenses available. There are different statutes of limitations. There are states that adopt one version of a rule versus another. So it's important to take that into account. And again, the insurance coverage comes into play here. You want insurance coverage that's going to cover you in any state if you're shipping into the US, because just because you ship the product into Montana doesn't mean that it might not be used in Idaho. And we'll talk a little bit about why that's a consideration when we get to the next few slides, and the state law will be different in most cases between one state to the next. Now, although the law, the substantive law, the rules that you have to comply with essentially are set at the state level, cases can be brought in either federal or state court. And if you're sued in state court as a Canadian manufacturer or distributor, you may be able to remove that case to federal court, and you may want to do that because although those courts apply the substantive law of the state in which they sit typically, federal procedural law applies, and there are some advantages, particularly to a foreign entity or a company that has its headquarters outside the US to being under the federal procedural law. It gives you a little more certainty. It's usually a better forum for defendants than the state. But again, it's a case-by-case basis. You'll want to talk to someone about that if you do find yourself facing a product liability suit in a state court. This slide highlights some of the key differences between the types of claims that can be brought in Canada versus the United States. Canada, essentially all of these defect claims have an element or showing of negligence that is part of it. So you have, of course, the design defect. You created the product's design in such a way that there was a flaw or a problem that leads to a risk or a heightened risk, and you were somehow negligent in doing so. You should have discovered that risk or should have designed out that risk. You didn't do it. Manufacturing defect, of course, something went wrong during your manufacturing process. You were negligent in not making sure that that process conformed to the expectations in the market that it would be manufactured safely. And what is sometimes called warning defect, a failure to provide adequate warnings to someone so that they can use the product safely and avoid the potential risks, or at least appreciate them and try to avoid them. In the United States, we have separate negligence cause of action or negligence causes of action in most states that are separate from the strict product liability. And strict product liability in the US typically does not require a showing of negligence. So you can have a negligence cause of action or a negligent design cause of action. You may also have a strict product liability claim based on design defect in the United States. And I'll talk a little bit about that test in a second. But that's an important distinction because you don't necessarily have a plaintiff in the US that needs to show you were negligent if they can meet the tests for strict product liability. And there's also, of course, breach of warranty liability in the US, which is somewhat similar to Canada with some distinctions about what you can and can't disclaim through your disclaimers of warranties. There's two primary tests for strict product liability claims, and we could talk about these at length. I'm only going to cover them very briefly. Different states have different rules and slightly different formulations of these tests, but the two primary tests are the consumer expectations test or the risk utility test. Consumer expectations is essentially explained by the title. What would an average consumer appreciate to be the risks of your product? If you have a laser engraver, the person may or may not expect that a laser can blind them. They may or may not expect that it could burn them if it can't blind them. They may think that they can reach in and move a product that's being engraved and not have a risk of getting burned if the laser is powerful enough and it would cause a burn, and the ordinary consumer wouldn't expect that. That product may be defective by virtue of the fact it doesn't meet that consumer expectations test. There is an unreasonable risk of harm in light of what the ordinary consumer will expect. The risk utility test is a weighing, a balancing. Does the risk of the product outweigh its utility? Is this a product that we're willing to accept a certain amount of risk because it does great things and that we really need? Or is it a product that we really are creating a risk here that's unreasonable given the limited benefit that we get from having the product on the market? And this test might be a legitimate concern if you're dealing with a hobby laser engraver that could cause burns or blindness or other types of injury. Notice in neither of those tests is negligence required. So if I have a product like a laser engraver, it's in the market, someone gets injured and they sue me in a state that has a risk utility test, the ultimate decision that's going to go to the court will be, does the risk of that product outweigh its utility? And that's typically a factual inquiry. So that's the type of claim that is tough to sometimes get rid of in the US on a motion for dismissal or for summary judgment. There are caveats to these rules. There are defenses that may allow you to get that relief. And some states do require the plaintiff to prove that there's the existence of an economically and technologically feasible alternative design that existed at the time the product left that manufacturer's control. So if someone comes along and says, but look, company B put a laser engraver on the market that has these great shields, and that product wasn't available or that design wasn't feasible because of a new material or a new manufacturing technique until after the product that you've sold has left your control, you may have a defense to that claim. And oftentimes that involves consideration of not only what else is on the market, what's been patented, what's been written about in the product literature that people can point to and say there's an alternative design available, usually the subject of expert testimony. So a couple of other considerations about US product liability laws. Statute of limitations vary by state and type of claim. New York, for example, 3 years is a typical statute of limitations for product liability and personal injury cases. Breach of warranty claims, if they're under what we call the Uniform Commercial Code, it's 4 years. So you need to make sure you have some awareness of what your exposure can be just on the limitations basis. There are also in certain US jurisdictions statutes of repose, and those are absolute bars. So if they apply, and there are only a few states that have them, they typically only apply to certain types of claims. If you sell a product into the market and 20 years later it causes an injury, if that state has a statute of repose that's 10 years from the date of sale, you're not going to be liable even if the person tries to sue within what otherwise would be the statute of limitations. Again, case by case, state by state, depends on your product and the types of products that state may have applied its statute of repose to. Damages caps are relatively rare in the United States. Again, there are a few states that have them. You would need to look at the state you're potentially being sued in as to whether or not that's available. And jury trials are typically the norm as opposed to trials before the bench or the judge. So when I mentioned earlier that you want to make sure you have insurance to cover you about the costs of defense, one of the reasons is defending a product's liability case in the United States can be more expensive than it is in Canada. In Canada, you have the affirmative obligation to provide at the outset of the litigation your relevant documents. No one has to ask you for them. You have that affirmative obligation in the case, and you provide them usually in an affidavit of documents that says, here's our relevant documents we've looked through and we found these. In the US, it's driven by the parties. There are some initial disclosures, but typically you're going to get a set of discovery demands from a plaintiff, and you don't have as much control over what goes in your initial disclosures because it's driven by what's being asked of you. You can object, but then there may be motion practice to compel you to produce things. There may be argument about whether or not you're entitled, the plaintiff's entitled to get those things from you, or you're entitled to withhold them. But it's a different process than it is in Canada to get those documents discovered. It usually takes longer, it's usually more intrusive, and it usually is more costly. In Canada, the examinations for discovery, the typical rule, you only get one deposition as the plaintiff of a company witness. That company witness has to investigate the claim and the relevant information and speaks for the company, and then there are follow-up questions that are posed in writing. Absent a showing of extremely good cause, most courts in Canada will not allow you to have more than one examination for discovery of a party, so you don't end up with serial depositions. In the US, it's different again. There are some limits under our federal rules to the number of depositions absent leave of court, but it is not at all unusual for a plaintiff to have 2, 3, 4 depositions of a corporate defendant if they have a claim that includes design, manufacturing, and warnings defects, because they may want to depose the people who are involved in the design. They may want to depose someone from the facility that manufactured it about what records exist about quality control or testing, and they may want to depose someone who helped write the warnings. And in the US, more likely than not, they're going to get those multiple depositions. So again, costly and time consuming. There's relatively limited expert discovery in Canada versus the US. Tends to be both reports and depositions in the US, depending on the court that you're in. Canada's motion practice tends to be more limited, in part because of the last item on the list. There can be the shifting of costs if you make a motion and you don't succeed upon it. In the US, we're more aggressive in our motion practice. So we would typically anticipate, as a matter of course, there's going to be some form of motion to dismiss early in a case to try to narrow the claims. And after discovery, if necessary, there's going to be a motion for summary judgment to try to get rid of what's left or narrow what actually has to be tried. And in the US, we don't have loser pays, so there's less of a disincentive for plaintiffs. So we see more cases that might not be brought in Canada. So turning back to our case study, just to sort of tie some of these points together, with our startup or a hypothetical startup, by selling those kits to customers in multiple states, that startup is exposing itself to liability in multiple states. In most instances, the residence of the party that is injured or the location of where the injury occurred will determine where you can be sued in the United States. So in the case of a Canadian entity, if you're headquartered in Toronto and you ship a kit out to Seattle, you may well be sued in Seattle if something goes wrong with your product, and then you have to defend that case even though it's most of the way across the continent. In this hypothetical case study, they're encouraging customers to modify the product and to share those modifications online. That gives up some potential defenses. Improper use can be somewhat reduced because if the person is availing themselves of what you've invited them to do, to modify the product, try new things, you may not be able to say, but don't try this or that. It may limit your ability to use that defense, as well as the defense of failure to follow instructions. So particularly in this climate, where we're dealing with hardware and software and open source products, you've got to think about that carefully when you're selling a product like that, if you are actually giving up these defenses by doing so. So if I was counseling this hypothetical startup, I'd tell them again, first you need to incorporate, you need to obtain the proper insurance coverage, you got to consider whether keeping the product open source is essential to your success or your business model, and you need to think about rewriting your instruction manual and warnings to provide maximum potential or maximum protection against potential claims. But even taking those steps, a startup like this would be potentially subject to product liability claims if the risk posed by the product outweighed its utility, or the product was more dangerous than would be contemplated by an ordinary consumer possessing ordinary common knowledge or knowledge common to the community. It can also be subject to liability if you have inadequate warnings, you don't give enough information about the dangers of the product, or if you make any warranties about its suitability to do certain things and it turns out the product is not as suitable for that use as perhaps you represented or warranted. So back to our key takeaways, comes full circle. Really, if you're already selling products in the US, you have that exposure. Hopefully you've taken the steps of making sure that your business entity is protected so that you have a corporation or a business organization that's going to provide you a level of protection. If you're considering expanding to the US, before you start selling that first product over here, you need to think about the legal and insurance advice to make sure you have as much protection as possible. That's essentially the overview, and then I can answer some questions as they come in.
Sounds good. Hot topic that I know is a conversation with clients that we work with often, and so this has been a great amount of just enough in-depth information. So yes, we'll go ahead now and take some questions. If you have any questions, please be sure to type your questions into the question box in your control panel. Following this presentation, you will receive an email with a link to Carolyn's calendar if you wish to schedule a conversation with her. You can also visit our website at buffaloniagara.org, where you can link to Carolyn's social accounts, email address, and download our expansion guides. Carolyn's services are free of charge to any company considering an expansion in the Buffalo Niagara region. She serves as a single point of contact and will connect you with experts like Craig that will ensure your expansion is a smooth one. So a first question we're going to take a look at here, if I have a product failure in the US, will I get sued in Canada?
Typically not. Typically, if you have a product failure occurring in the US, unless it involves a Canadian citizen, you're typically going to be subject to exposure in the United States, because most residents of the US will look to sue in the US rather than trying to sue you in Canada. The fact that you've shipped the product or sent the product into distribution, it winds up in the US and the person is injured in the US, usually gives that person a toehold in the US courts. And because of some of those disadvantages to companies of litigating in the US, most plaintiffs' attorneys would tell them, bring the suit in the US, you'll be in a better position than you would trying to sue in Canada, particularly with some of the damages caps and other protections that manufacturers and distributors may have in Canada.
What if there's a problem with my product due to user error? Can I still get sued?
Unfortunately, yes, and this is one we see commonly. We see a lot of cases where it is misuse of the product, or the product in some instances has been inadequately maintained. It hasn't been serviced appropriately. It hasn't been treated appropriately. It's been exposed to conditions or uses that it shouldn't have been. It doesn't mean that you can't get sued. It may mean that you have a defense that could get you out on a motion to dismiss or a motion for summary judgment, but it doesn't preclude the person that used the product from suing you. And there again is where the insurance and corporate entity come into play, because that's part of your protection. The cost of defending the suit in many of these cases can be higher than whatever exposure you may ultimately have for the injury, depending on what type of injury it is and depending upon the degree of misuse. Now, I do have to say, there is a doctrine of foreseeable misuse. So if, for example, in our laser engraver situation, people know that it's being used to engrave or someone decides to use it to brand themselves or tattoo with body modification these days, and you're aware of it, in this case they're asking people to say, what are you using this product for, how are you modifying it, and you allow it to be sold without telling people don't do that and without telling people you shouldn't do that, and there's an injury, that's a foreseeable misuse, and for that the user misuse may not preclude liability.
So our presentation today talked a lot about business to consumer. Is this liability substantially different for business to business as opposed to what we talked about, business to consumer?
There can still be claims that are essentially product related business to business. One of the advantages you have as business to business is you have your terms and conditions of sale. So if you're selling to another business, you want to make sure that that terms and conditions, or those terms and conditions, are detailed in terms of any warranties you're disclaiming. You want to make sure that the terms and conditions reflect what perhaps you want to do in terms of if there's a problem. There can be provisions in those agreements that include, or in those terms that include, arbitration as opposed to going to a legal forum. But at the end of the day, if you don't do those things, if you wind up in a situation where you sell a product to a business, that business uses the product, there is a problem with it, it causes other damages, that business will likely be able to sue you. Some of the theories are different, and some of the knowledge that that business is charged with is different, particularly if it's in an industry where they use that product or have familiarity or knowledge about that product. Say you're a crane manufacturer in the US and you're getting a component part that's a shackle from Canada. Well, as a crane manufacturer, you have more knowledge about that type of product than the average consumer. It may give the seller more defenses, but it will not absolutely preclude a lawsuit. So there's exposure there. It's slightly different.
So in your example, you talked about a manual being part of the product. And so we have a question here about translation. If the owner-operator manual is only in English, can a business claim that it should have been available in other languages?
Potentially, yes. It depends where you're shipping the product to and what the expectation of the industry is. So there are essentially the expectations that you will comply with what is the accepted practice in an industry in those sort of situations. So for example, if you go to Home Depot and you pick up a power tool these days, you'll probably get a manual that has English, French, Spanish, at a minimum those three, and maybe Chinese or another language depending upon where the manufacturer is shipping those products. Now, part of that is they want to make one manual and have it consistent across the various jurisdictions. But the other part of it is if there is foreseeable use by a non-English speaking entity, business, individual, and you don't provide that warning, there is some enhanced exposure if you don't provide warnings in the languages that are reasonably foreseeable that you may have to deal with in terms of your user or the business that's getting it.
Okay, next question. If I have a product failure in the US, should I call my Canadian lawyer or should I use a US lawyer?
There's a bit of both here because obviously your Canadian lawyer is probably already familiar with your corporate form and some of the insurance that you may have. But ultimately, if you're defending a products liability suit in the US, you're going to need US counsel or someone who is cross-border qualified because of the fact that is going to take place in the US courts. And you're going to need someone who has the ability to appear in court, file papers, and deal with the legal issues that come from being sued in one of our 50 states.
Our next question we've gotten on most webinars, and so you can refer back to past webinars if you'd like. But Craig, you could probably answer this a little bit too. How do I incorporate my business into the US?
Sure, it's relatively easy. I don't do corporate formation work as part of my practice, but we deal with it tangentially. And I mean, forming a corporate entity in the US, there's different forms of entity you can form depending on your type of business and what you want to achieve, from limited liability companies to partnerships to fully incorporated businesses. So the nuances of that are best discussed with someone who works in corporate formation, but the actual process of incorporating is relatively easy and can be done for a relatively inexpensive amount of money. It's something you want to do right up front, and it's worth that investment. And you're talking in the scale of $1,000 or less often, depending on the complexity. It can be more expensive, but you're talking about a relatively minimal investment in order to get the protection that your personal assets aren't going to be at risk.
So if you're thinking of expanding to the US and you go to our website, buffaloniagara.org, we do have a checklist, a handy little checklist. It may seem overwhelming, but really once you speak with Carolyn and the experts that she's able to bring you into and speak to here in our offices, you'll find, like as you said, it's actually an easy process once you're talking to the right experts. And this may be our last question. If I incorporate my business in Delaware versus another state, does that give me more product protection?
Typically not. Delaware is a favorable jurisdiction for corporate formation for other reasons, but the exposure that you're going to have with respect to products liability is far more dependent upon where the injury occurs than it is on where you're incorporated, because that state will be the state's law that typically applies. So any damages caps or other issues are going to be determined by that state's law, not by the state where you're incorporated. It also doesn't make much of a difference to where you could be sued if you were thinking that you could incorporate a particular state and increase your odds that you're not going to face suit in other states. It really typically doesn't come into play in products liability cases because there is specific jurisdiction with respect to your sale of that product into that jurisdiction or the use of your product in that jurisdiction resulting in injury. Most states have statutes that would subject you to liability there. There's some exceptions and some defenses, but they're not based upon your state of incorporation for the most part.
Okay, it looks like we've answered all of our questions, and if we have missed any, we will have a report that shows them, and we will be sure to email you those responses. Thank you, everyone, for joining us today. We appreciate you joining this presentation, and especially thank you, Craig, for your expertise and presentation. Your email is here on the screen as well if anyone would like to reach out to you directly, but again, you can reach out to Carolyn as well, and she will set you up with a number of different professionals that can help you not only with legal, also, as you mentioned, insurance, and help you look at properties too if you're looking to expand to the U.S. So thank you for joining us. Have a great afternoon.